Hi, I'm Rod Khleif. Each and every week, I record an interview with a thought leader that I know you're going to get a ton of value from. Now, here on YouTube are the video versions of my podcast, Lifetime Cash Flow Through Real Estate Investing. Now, to make sure you get the latest information, please subscribe and hit the notification bell. Let's get started. Welcome to another edition of How to Build Lifetime Cash Flow Through Real Estate Investing. I'm Rod Khleif, and I'm thrilled you're here. And this is a little funny. The guy I'm interviewing today, I previously interviewed, and Rod, who is old as dirt, forgot to hit the record button. So he has been gracious enough. It was really embarrassing when this happened. We're halfway through an awesome interview, and he's been gracious enough to come back on the show. His name's attorney Mark Roderick, and we're actually using Mark. He's an SEC attorney. We're actually using him for one of our deals, and really excited to start a relationship. But his resume is really very, very impressive, and we're gonna dig into syndications on this show, and just very lucky to have him. Mark, welcome to the show, my friend.
Thank you very much for having me again.
Oh man, the humiliation never ends. You know, I was telling you before we recorded, I've had two of my team members text me and message me to make sure I hit the record button, and you know, it's just never pretty cold. But anyway, welcome, my friend. So let's get right into it. I know, you know, you've been practicing for a long time, 25 years, and you represent individuals in business, in all sorts of business type, what's the word I'm looking for? Needs, business needs. But really, we're going to talk about your SEC experience today. So if you don't mind, let's just get right to it and talk about why someone needs you, and maybe a brief overview of, you know, the syndication process, the exemption process, and the different nuances associated therewith.
Okay, well, let me try to jump in and make it all make sense in some context. And yes,
Awesome.
I've actually been practicing, as I always say, since 1840, so a lot of years. So what is all this about? Let's try to put it in an overall context, because that's the way my brain thinks better. So if you're a real estate guy like you, and you know, you have a project you want to buy, a value add multifamily, for example, very hot sector these days, and of course you can just do it yourself, and you need a lawyer, you need a real estate lawyer. You're going to buy the real estate, you're going to invest your own money, put it on your credit cards, or you're a wealthy guy. You have the money, you borrow money from banks, you do it all yourself, no problem. There are no securities laws involved there, so you don't have to call me or another securities lawyers. The minute you say to yourself, hey, you know, I think I could do better if I used other people's money, OPM. I want to use other people's money, and you know what? I'm doing them a favor because I'm getting them involved in a really good deal, and they're going to make money, I'm going to make money, and because now I'm using their money, now instead of doing one deal at a time, which exhausts all my capital, now I can do 4 deals because I can put a little bit of my money in each deal, but you know, fill out that capital stack with other people's money. So the minute I use other people's money, that's when securities laws leap into play. And the sort of big overview, the US securities laws, our modern securities laws were all enacted in the 1930s after and in response to the Great Depression. And that's why you have like the Securities Act of 1933, the Exchange Act of 1934. That's not coincidental, because the Great Depression was in many senses caused by the complete collapse of the American capital markets. And so one of the first things he did when he was elected in 1932, Franklin Roosevelt took steps to reinvigorate the American capital market. So that's where all our laws date from. Anyway, general rule is anytime you use other people's money in whatever form, whether you borrow money, whether it's from your grandmother or a complete stranger, if it's other people's money, you're using, then that means the securities laws come into effect. And the general rule of the securities laws is that you have to register. So if you want to use other people's money, you start with the general proposition that you have to spend millions of dollars to fully register your company and the offering with the SEC, the same way like a big company like Facebook would. However, of course, that would be ridiculous if every little company had to do that. So there are exemptions. That's why you hear securities lawyers talk about exemptions. They mean exemptions from the registration requirement. And there are all kinds of exemptions. And a lot of what securities lawyers like me do is they look at a given transaction and they say, well, what exemption would work best for you? There's not just one exemption, there are dozens of exemptions. And we're going to talk about some of them today. But the key is, to put it in context, these are all exemptions to the overriding registration requirement in Section 5 of the Securities Act. So that's everything we're talking about is a subset.
So that's the overview.
That's the overview.
So let's dig into the three most common exemptions that you encounter. So let's start with the 506B, if you don't mind.
Sure.
Okay.
So 506B, that is an exemption that has been around since 1982. And for you and many of your listeners, that's kind of the old-fashioned private placement exemption. And basically what it says is that if you follow a few rules, which I'll talk about, then you're exempt. You don't have to register. You don't have to spend millions of dollars. And what is more, if you qualify under Rule 506B, which is a federal rule, then you also don't have to register under any of the state registration laws, because in our federalist system, federal government has a securities laws. Every state has its own securities laws. So 506B, there are very few requirements. One requirement is that either all of your investors are accredited, okay, or you can have up to 35 in each deal, 35 non-accredited. So that's one rule, the kinds of investors. You can either have all accredited or up to 35 non-accredited in each deal.
Now, if you don't mind, let's digress for 1 second and talk about what accredited is before we move further,
Sure.
if that's okay. All right.
Sure, absolutely. And again, I'll just go quickly back to the historical context. One of the fundamental features in our securities laws since 1933 has been rich people can protect themselves because they can hire accountants and lawyers and other people like that. And non-rich people cannot protect themselves and need the paternalistic arm of the government around their shoulders. And that system has worked pretty darn well. And so the term accredited, what it really means, used to mean, is rich people. And so there have always been different sets of rules, whether you were selling to rich people or non-rich people. Accredited, the definition comes from 1982. And for a person, an individual human being, it means your income is at least 200 or 300 with your spouse, or your net worth is $1 million without your house. Now, as you know, you and your listeners probably immediately realize those numbers were a lot bigger in 1982 than they are now. They have not been changed, not been indexed for inflation. So is rich 200,000? Well, it's not poor, but it's not what it used to be in 1982.
Oh, that's a very interesting distinction. I hadn't even thought about that. And yeah, back in 82, let's see, I was 22 years old. A couple $100,000 was big money.
Absolutely.
Right.
Yeah,
Okay.
it was, you know, I think the equivalent inflation adjusted is $500,000 or $600,000 today.
Yeah.
So, yeah, so the value has really diminished, and yet the SEC hasn't changed those numbers. And what that actually means, as an aside, is there's a lot less wrongdoing in the private securities markets than people thought there was going to be. But that's just an aside.
So again, not to go down another rabbit hole, but kind of have to circle back on something else because, you know, there's also the term sophisticated. Can you just speak to that for a moment? Because I know in our last conversation, you really said everybody else, but can you kind of just, you know, go dig deep?
Yeah.
Deeper in that?
So technically, for someone to invest in a Rule 506B offering, the person either has to be accredited or be, by definition, non-accredited, but also sophisticated, able to count to 10 is what that really amounts to. So you always see on the questionnaires, yes, I'm a really sophisticated person. You know,
So it's self-policed. So basically,
and I have never, as I said for the first time around, I've never in my career of doing this for a long time had someone say, "No, I'm not sophisticated. You know, I'm the dummy in the room." So, although that is technically a requirement, I've actually never seen it come into play. Now, if it does, if you have someone that says, "Man, I am just dumb. I don't know even how I got here," that person can still invest if he or she has a purchaser representative who is qualified. In other words, someone to hold his hand through the process. But again, no one ever says that they're not sophisticated.
So there you have it, guys, because I get this question a lot. So there you have it. Okay, well, I appreciate you digressing on that. So back to the requirements for a 506B.
Yes, and I'm almost done because there aren't very many.
Well, awesome.
So who can participate is one, and it's either accredited or up to 35 sophisticated. And you think about, Steve Martin, the old skits from Saturday Night Live. We are wild and crazy guys. So that's the sophistication standard. And then the other requirement is that if there are any, even one, non-accredited investor, then you have to provide specified information. A fairly thick book of information. Again, that's consistent. It's not arbitrary. It's consistent with this theme of, the government, non-wealthy people need the government's protection. So who can participate? What information is provided? And those are the two requirements of Rule 506B. And not surprisingly, 506B has been extremely popular. Billions, trillions of dollars have been raised using Rule 506B.
Yeah, I mean, I remember back in the day when I was wet behind the ears that we had what was called the 3-touch rule. You had to have a relationship with the quote unquote sophisticated investor. You couldn't advertise to them. Right?
That is correct. Yeah. Right. Yeah, but I should have said that. Yeah. The old 506B, no advertising.
Right. So you can't advertise under that one at all. And I'm seeing people bump up against that right now. In fact, I just got an email this morning that I really felt like crossed the line as with a 506B offering. But anyway, so 35 non-accredited, sophisticated, quote unquote, investors, and the rest can be all accredited and you can't advertise. So then Now let's talk about what then became the belle of the ball back with, I think it was with Dodd-Frank, right? Which was 506C?
It wasn't Dodd-Frank. It was the Jobs Act.
Jobs Act. That's it. Okay.
Jumpstart Our Businesses Act, signed into law by President Obama in 2012. So one of the other central tenets of securities laws, as you have just reminded me, was that public deals you could advertise, Facebook you can advertise. Private deals, your little real estate syndication, you could not advertise.
So just let me exclamation mark what you just said, because what he means by public deals is like an IPO, okay? Like he used Facebook as an example. Anything on the stock exchange, you can advertise because they spend millions of dollars for that, or really a lot of money, and maybe not millions in some cases, but a lot of money to be able to do that through an SEC licensed dealer and all of that business. So, okay. Please
continue. but private deals, you couldn't advertise.
Right.
And so any of you or your listeners who has been through the money raising process over the last 35 years knows what that led to. It led to a highly fragmented, highly inefficient system where it matters whom you know. So when you wanted to raise money for that syndication, the first one you did, you thought, well, let's see. Who are my buddies? Who's my accountant? Who's my lawyer? Do they have any money? Do they know people who have money? So you start making phone calls, you start going to meetings, but you're reaching people very inefficiently because it just depends on whom you happen to know, where you live, right? It's a lot easier to raise money in Manhattan than it is in South Dakota and all those things. Super inefficient market. Along comes the Jobs Act and says, for the first time in the history of U.S. securities laws, even these little private deals, your real estate syndication, you can now advertise in any way you want to. So now, rather than only calling your lawyer or your accountant or members of your country club, and I know you belong to several, you're very well known for that, but now you can, any of your listeners this afternoon can put up a website that potentially reaches every freaking investor in the world, okay? And that you can tell, I mean, that is just such a super big deal.
Oh, I mean, it was so huge when it was announced. It was like, oh my God, the clouds have parted. Now you can, really, maximize this incredible opportunity. So
yes, and let me just make a couple points there. Mm-hmm. One, it's just the internet. I always say, fortunately, there's lots of legal rules behind all this stuff. So like you have to hire me, thank goodness.
Right. But
it's just the internet. And that's what your listeners should think. This is just the internet coming to the capital formation business. It's that simple. What does the internet do when it came to the retail industry or to the music industry or to the travel industry, the taxi cab industry or Match.com? What it does is allows buyers and sellers to connect directly without all those middlemen. And if you just think about that.
No, I love that analogy. Yeah, I love it.
The role the internet plays in our lives generally, the Jobs Act is just allowing the internet to infiltrate, kind of get the camel's nose under the tent into the capital formation industry. Capital formation industry is a gigantic industry compared to travel or Airbnb, multi-trillion-dollar a year industry in dire need of disruption. So that's one point I wanted to make. And the other point, which often gets lost because people like you and me, you're a syndicator. I'm a lawyer who represents syndicators. So we talk about it from the seller's point of view. But it's absolutely critical to bear in mind that the only reason this works is not only is it great for you because you can reach every investor in the world, it's great for the investors because for the first time in American history, ordinary average American investors can now see every deal in the world.
Yep.
So
which was previously really reserved for, people with money in the country club set and all of that.
That's exactly the point.
No, I'm really glad you said that. I didn't, really.
But I mean, that's why it works,
right?
And that's why the more it grows, we're all better off because
love it.
It democratizes capital, and let's talk about
love it.
And so seriously, I mean, it's really seriously great stuff.
Yeah. So 506C.
506C. Is just like 506B, but a couple tweaks. One tweak is that only accredited investors can participate.
Right.
So 506B, I set up to 35 non-accrediteds, not in 506C, only accrediteds. And the second rule, as we've just talked about, is you can advertise.
Right.
There's no advertising you cannot do. You can advertise on the internet. You can pull a banner behind a plane at the shore. any advertising is permitted. Doesn't mean you can lie in your advertising,
Right.
but the form of advertising is unlimited in Rule 506C.
Yeah, it's a beautiful thing. Beautiful thing. Okay.
Let me just say, so I actually, this question, difference between 506B, 506C always comes up. I wrote a blog post about it. And here's the example that I used in my blog post that seems to kind of draw the right picture for most people. You have a jewelry store, and there's two ways to get customers in the door. One way is in the store window, there's no jewelry, but there's a sign that says, we have a lot of beautiful jewelry inside. And maybe there's a handsome groom and a handsome bride, and he's proposing, and you sort of paints a picture of, wow, jewelry is wonderful. You have to come in the door and introduce yourself to see the jewelry. That's a Rule 506B deal. The 506C deal is the jewelry is right there in the window. It's gorgeous, pearls, diamonds, whatever.
Right.
And that's a 506C deal, because you're advertising 506C. There it is, right there, the deal. It's not an invitation to see a deal. It is the deal.
Got it. Yeah. No, that's awesome. That's awesome. Can we now talk about, I guess, what's becoming one of the bells of the ball, Reg A? Yes,
we can. And Reg A, just like Rule 506B and Rule 506C, is just another exemption to the general registration requirement. Totally different than Rule 506. Right. The main features of Regulation A, and it's often called Regulation A+, but there's really no
right.
thing. It's just Regulation A. So the main feature is you are allowed to sell to non-accredited investors. 506B, you can sell up to 35 non-accredited investors. Regulation A, you can sell to thousands.
Wow.
Really as many non-accrediteds as you want. There is a limit on how much you can raise. You can raise up to $50 million per year, which for your normal syndicator, it's like huge. That's a huge deal. For a big public company, it's a small deal. But you can raise up to $50 million a year. You can include as many non-accredited investors as you want. But again, the paternalistic arm of the government, non-accredited investors, the price of admission to be able to do that is you have to put together a big, thick book for the SEC, and not only put it together, but you have to have it approved by the SEC. So it is very much like that Facebook full public offering, not quite as extensive, but it's a time-consuming and, relatively speaking, expensive process.
Can we speak about how expensive? I mean, what you've seen out there as far as a range to do a Reg A. I know you have to have an audit of the books. Now, you could be auditing a checking account that hasn't had any activity, I would guess, in that scenario, in some scenarios. But is that correct? Could you expand?
That is correct.
Okay.
Yeah. So you do have to have an audited financial statements. Mm-hmm. Those are not very expensive, and for a startup, they're nothing at all.
Right.
The cost is in paying me or someone like me to put together the book and get it through the SEC, and the cost is going to be between good numbers between $50,000 and $75,000.
Okay.
Unless you go to a big Manhattan firm, and then it's $350,000.
And what about the timeline?
The timeline, if you have a pretty straightforward deal these days, 5 months is a pretty good timeline from like starting today. I have at my blog a whole section of the blog called Regulation A Resources, all about Regulation A. But to answer your question, one of the items there is this beautiful graphic timeline, week by week, showing what you should be doing each week during that period. But about 5 months.
Do you find that most people are using that vehicle for funds? versus property specific needs?
Yes.
Okay.
So far, pretty much exclusively. So
Funds,
by
yeah.
fund,
So you put a fund together so
yep.
you can buy multiple properties, and that's and what's beautiful about it though is if you know you have enough of an advertising acumen, or you have a big enough Rolodex, for lack of a better word, list of potential clients, then you can take non-accredited investors and really open it up. So. Yeah.
That is right. And you just hit on the key point. So people say, I was speaking yesterday, actually, to a group just like you guys, super good at marketing, very successful. They know what they're doing. And they said, well, should we, we've been very successful using Rule 506C, should we expand to Regulation A? The answer is not necessarily, oh, absolutely, get
Right.
bigger and bigger. But the answer is if you want to raise money from non-accredited investors. And there's a couple reasons why you might.
Mm-hmm.
One is non-accredited investors have money. So sure, the more capital,
Right.
the deeper your well of capital, the better. And the other is a more idealistic reason. And I've had a bunch of people say this to me. We have great deals. We want to make them available to the broader American public. And that is a perfectly legitimate reason for expanding from Rule 506C to Regulation A.
Yeah, I've seen some of my contemporaries, offer these Reg A offerings, and they're letting people in with a minimum of $5,000, which is, a whole lot of hand holding, but hey, whatever works, it's almost like
I've had clients do very successful Regulation A offerings at $100.
wow,
$100.
wow,
and
that's
that came from idealism. Really, folks really wanting to say, hey, we want the American public, everyone in the American public.
I love that motivation. If that's real, that's a beautiful thing. Absolutely love it. So let's talk for a minute now about the documentation required. Let's take the mystery out of, people think syndication, oh my God, that's so intimidating. It's so scary. Can we demystify, the process and the documents involved?
I certainly hope not. No,
well, enough where they still need you. They know they need you, but
it's very mysterious. Let me start the smoke signals coming up here because it's a big mystery. So in any syndication, what you're really talking about is 3 documents.
Right.
One document is often called the subscription agreement. It used to be called, I call it an investment agreement because no one knows what the heck a subscription agreement is. And it's just a document whereby the investor agrees to invest in your deal.
Right.
And they are like so many things in the law. The law is like a ship in the sea and it collects barnacles. And so these things get longer and longer and longer. They never get shorter, but
kind of like the tax code.
Like the tax code. So the subscription agreement or investment agreement should be a pretty simple, straightforward document. Mm-hmm. I hereby agree to buy this limited liability company interest. That's the subscription agreement.
Buy a membership interest in this LLC. Yeah. Okay.
Exactly.
All
okay.
right.
That's one document.
Mm-hmm.
Very straightforward. The other document is the partnership agreement or operating agreement or limited liability company agreement, the agreement that governs the organization that owns the real estate.
The entity.
The entity agreement. Let's call it that. Mm-hmm. And that's the agreement that it says a lot of important things, but it talks about how much money people are going to contribute. It talks about who's going to make decisions, which in your case, you're the syndicator, you're going to make all the decisions. And then critically, it talks about how the money's going to get distributed. So that's when your deal has a 7% preferred return with a 30% promote. That's the agreement that spells out those cryptic sounding terms in hopefully understandable, crisp, clear language that is not ambiguous. It also includes other stuff. If you're the syndicator and I'm representing you, I put all kinds of stuff in there to protect you. that, you know, says investors can't sue you even if you make mistakes and stuff like that. But so that's the entity agreement that governs the actual operation of things. That's two agreements.
Back in the day, it used to be a general partnership agreement, and you'd have a general partner and limited partners. But now the bell of the ball for entities is obviously LLCs, limited liability companies.
That is correct.
Okay. All right.
And then the third document is generically the disclosure document. It's often called a PPM, which stands for Private Placement Memorandum. But again, no one knows what that means. So I call it a disclosure document because that's what it is. It's a big document that hopefully describes the deal to investors in enough detail that they understand the deal, the potential benefits of the deal, and the risks of the deal. So that's the thickest of the three documents, and it takes the longest to produce. They are...
Well, that PPM, let's hone in on that for 1 second. That's the document that will tell you how everything can go wrong and what can go wrong. And it's really disclosing every potential risk as much as possible and not sugarcoating it, right?
Not sugarcoating it at all. You know, the first time, I've had the experience so many times, a client who's never done it before comes to me. I prepare the disclosure document for him. I send it to him. He's eagerly awaiting it. He calls me and says, "What did you do?" Nobody's going to invest in this deal if they read this. And then I say, okay, well then I know I was successful writing that. Because, I mean, it should talk about the benefits of the deal too, but it does talk about risks because these are, after all, risky ventures. In the real estate market we've had for the last 10 years, I think we've all forgotten some of those risks.
Oh yeah.
But you and I are both old enough to know that what goes around comes around.
Right. Yeah, no. And that's the document that protects you guys. I mean, that's why you want it as comprehensive and you do not want to minimize any of the disclaimers and the risks associated with the deal. And that's why you need someone like Mark here for sure.
Well,
so go ahead.
You also, I mean, this is a pet peeve of mine. Legal documents are a pet peeve of mine because usually they're so bad and unreadable. And so you want that thing to be readable. You want someone of an 8th grade education to be able to sit down and read it and understand what they're getting into. That is ideally what you would like.
No, I love it. That makes complete sense. So let me ask you this. What should a passive investor look for in one of these documents? I mean, can you give a few tips? We'll kind of round out the interview with that. What should someone look for?
Well, that question, excellent question. It raises some fundamental issues about all of our securities laws. And I say that for this reason, because you're a real estate expert, right? I'm not. I'm a real estate lawyer expert, but I'm not a real estate expert. I have written more of these documents that I could possibly count. And yet, if I'm a passive investor looking at a private placement memorandum or disclosure document from scratch, I am actually, truth be told, going to have a really hard time deciding whether this is a good deal, okay? You're an expert. You're going to look at that deal and you're going to say, well, what about this? What about this? Because you know real estate.
Right.
The kind of ugly truth behind all of this legal stuff is that most passive investors simply do not have the knowledge, no matter how long the document is, to be able to distinguish a good deal from a not so good deal.
I'm so glad you said that. I am so glad you said that because I've been shouting from the rooftops that if you're going to invest in anything, for God's sakes, have a basic understanding of it. I don't care if it's an IPO or a business or the stock market or real estate. And and let me just say this. I mean, I do 3-day events and we dig into this, and they're cheap, and it's just me on stage for 3 days teaching. And it's kind of a no-brainer to spend a couple $100 to come sit and watch my ugly mug for 3 days to have a basic understanding of this business, because it's so critical. And so I'm so glad you said that. And
well, yeah, I mean, so now we'll get down to actually answering your question.
All right.
For me, for a passive investor, the documents are part of the equation,
right?
Not the most part. By far, the most important part is whom I'm investing
The
with.
operator.
The operator.
Yes.
If I know you, I know your track record. That's what I'm investing with.
Right.
And that is 80%. Now, at the same time, to answer your question, if I'm a passive investor and I open the documents and I don't understand them, if they're duplicative and they just don't seem to make sense, then I would stay away. Right. Because there tends to be, and there is a correlation, again, in my 100 years of practicing law, there's a correlation between sloppy documents and sloppy operators.
Couldn't agree more.
And there's also a correlation between good, concise documents and good, concise operators. I don't know why exactly, but there is a correlation there. So if I know the operator, I know his track record, and the documents make sense, even though I'm not a real estate expert, I'll invest. If they don't, I won't. That's my best advice.
Yeah, no, that's very sound and high level for sure way to protect yourself, because somebody that's been around a long time and and ideally even gone through a contraction and seen what can happen, it really makes a big difference. There are a lot of deals I'm seeing right now that frankly make the hair on the back of my neck stand up. We'll be in the best and final on a deal, and then somebody comes in and pays millions more, and I'm just scratching my head, and we just had a conversation about this with my CFO Robert and my students about how an operator can adjust the split to make a mediocre deal look better, and it's just a little scary. But
I think, and I know we're reaching the end of the time. I think that it's a real challenge for like you as a successful operator these days to be explaining to investors that, listen, the market is not what it was 5 years ago. The deals are harder to come by. So we're going to project probably lower yields on the deal we're selling you today than we did 4 years ago. That's not because we're bad guys.
Right.
It's because we're good guys.
And lower leverage. Like we're doing our deals at 65% loan to value right now. And there's deals out there at 80%. And people are, so like comparing an 80% leverage deal that may be a 90-10 split to the investor to a 65% leverage deal that's only maybe a 70-30 split, for example. Which deal's better? And I'm going to tell you it's going to be the lower leveraged ones, because they're safer. And we've seen deals where they haven't stress tested them, to make sure they can survive a contraction, or they don't have hardly anything in operating capital for a rainy day fund. It's just kind of some scary stuff. And guys, I'll dig into this a little bit more, but I'm not going to take any more of Mark's time. Thank you so much, brother, first of all, for coming back. And then second of all, for the incredible wisdom you've shared. Now, your website address, correct me if I'm wrong, is crowdfundattny, like attorney abbreviated, crowdfundattny.com, correct?
That is correct.
And that's where your blog is as well?
That is my blog.
Perfect. Well, that's got to be an incredible resource. I'm looking forward to seeing how our deal goes together, and it's really been a treat today, Mark. I appreciate your wisdom, and I look forward to shaking your hand one day soon.
Thank you very much. Same here, Rod.
All right, take care, my friend.
Take care. Bye-bye.
All right, see you.
Hey, thanks for watching. Please subscribe to my channel. And if you listen to podcasts, join me on iTunes, Stitcher, or wherever you listen to those podcasts. Just search for Lifetime Cash Flow through Real Estate Investing.